Hi, and welcome back to Chapter 6 in your workers' compensation curriculum. Today we're going to talk about the hearing system and the different paperwork that goes along with filing a claim and pursuing a claim. We'll discuss the issue of contested disputes between employee and employers with regards to workers' compensation benefits. We'll also discuss contested hearings, including how the parties prepare for the hearings, the paperwork involved in bringing a claim, and when and how the hearings are actually conducted. We'll also begin to address the issue of benefit disputes and how they lead to workers' compensation hearings. The vast majority of workers' compensation cases are uncontested. In other words, there's no real issues of dispute between the employer and the employee. There are some situations, however, where a hearing might be necessary if the employer contests the award of benefits to an employee. On the other side, if the employee's benefits are not what they expected, or if they're terminated prior to when they expected. If an employee's medical provider declares an employee is ready to return to work and the employee doesn't think so, there's a contest there that has to be resolved in some way, shape, or form. So either the employee or the employer can request a hearing before the Workers' Compensation Board when they have this type of dispute. So when a dispute arises between the employer and the employee, generally speaking, they request a hearing. A hearing, in some ways, very much mirrors a civil trial. And in some ways, it doesn't. We're going to talk about the differences a little bit here today. But in order to start the process, either the employer or the employee has to file a claim. It's a form-driven process, and much like a civil trial, where we file a complaint, in a workers' compensation case, we file a claim. There's an Exhibit 6-2 in your book that shows you that exact form for a given state. And essentially, this form just notifies the other side that there's an official contest and some issue in the case that has to be resolved by a third party. As with civil trials and criminal trials, statutes of limitations apply. And you want to be aware of either the 12 or 24-month statute of limitation from the time of the injury. If the claim isn't brought within that statute of limitations, as in a civil trial, the claim itself can be barred. Once the claim has been filed, each of the parties will receive a notice of hearing, which puts both sides on notice that there will be some type of administrative hearing in front of the Workers' Compensation Board, and it starts the process rolling. It gives them some dates and allows them to start to prepare their cases. As I said, these hearings are very much form-driven, and if you look at Exhibits 6.4 through 6.6 in your book, you'll see some of the forms that we use. And the Workers' Compensation Board is going to use these forms to collect information about the claims. It's very important that these forms are filled out completely. If they are not completed, the state will reject the forms and ask the party that filed them to go back to the drawing board and start over and complete these forms. And the whole process tends to get slowed down if the forms are not filled out correctly. During the pre-hearing phase, the parties to the claim on either side are going to begin to prepare for the hearing. And this process, just like it is in a civil trial, is called discovery, although it is quite a bit different. Discovery in a civil trial is very broad, and in a workers' compensation situation, it can be very limited, and in some states even refuse the right to discovery. But there still is a discovery process that the parties are going to go through. The most common discovery tools used in the workers' compensation system are depositions, interrogatories, requests for production of medical records, and for independent medical examinations. Where discovery is available, it is mandatory, and refusal to abide by a discovery request can bring sanctions from the administrative law judge. One such sanction is to prohibit a party from presenting evidence on a contested issue or even to dismiss certain claims. Both sides of the aisle here, both the employees and the employers, have the right to see the entire contents of the employee files, but they're not public records. They can't be viewed by someone who has a general interest in the case. They can only be viewed by real parties in interest to the hearing. The file is a living, breathing thing, and both sides are free to add documents as the process plays itself out. Keep in mind this is an administrative hearing, so some of the rules are relaxed and evidence can be added to the file as we go along. There are several steps to the process other than discovery, and they are meant to, as we see in civil trials, try to give the parties opportunities to settle. The first is going to be called a benefits review conference, and it's where the employer and employee sit down and try to hash out their differences in an informal setting. If they can settle their differences at this point, there's no need for the full-blown hearing. The next step would be an arbitration hearing, and again, still informal, but there's going to be a third party there who acts as an arbitrator and tries to help the parties to work out their differences prior to hearing. And finally, if we've made it through discovery and the other pretrial process or pre-hearing processes, we make it to the workers' compensation hearing. These are not courtroom hearings, they're administrative hearings, and they feel a lot more like meetings than they do trials. They tend to be held in less formal settings, conference rooms and boardrooms and things like that. One of the reasons they're held in less formal settings is to make it more convenient for employers and employees around the states. Most states provide offices around the state for the actual hearings, and there are multiple sites as a way to decrease travel time and other discomforts associated with the long trips you might otherwise have to make to a courtroom. Both parties are allowed to, not required to, but allowed to be represented at the hearing. Many states require that a person who represents a third party at a workers' compensation be an attorney, but some states allow non-lawyers to represent others. In most jurisdictions, the employee has the opportunity to represent themselves or be represented by an attorney. Depending on which side the attorneys work for, there are different fee structures. Usually, attorneys who represent the employee side are working on a contingency fee, which of course means that the attorney doesn't get paid unless there is some type of recovery on the employee's behalf, and it's usually based on the total recovery. Attorneys who represent employers, companies, are usually they usually charge by the hour, and there are evidentiary rules that apply at the hearing, but they are greatly relaxed compared to those in a civil or criminal case. For instance, the hearsay rules do not apply. And the reason for this liberal approach to evidence is that workers' compensation hearings are not trying to determine guilt or innocence. They're just trying to determine whether or not the benefits are correctly applied. Hearings are held in front of administrative law judges, and at first blush it may look like an ALJ, administrative law judge, is a lot like a judge in a civil or criminal trial. However, for administrative hearings, the administrative law judge not only acts as the judge, but also the jury, the decider of fact. The administrative law judge has broad powers in the hearing, the power to rule for or against either party, to dismiss certain specific issues raised by the parties, or even just to dismiss the entire case. Many of these powers are similar to those of a civil or criminal judge. And at the conclusion of the case, of course, the administrative law judge has the power to enter a ruling against either party. It usually doesn't come right away. It usually comes about 60 days, within a 60-day time frame after the hearing itself. The conduct of the hearing itself, again, resembles a trial in some significant ways. Common practice is for attorneys to make some opening remarks before the case begins. Then witnesses are presented. There are almost always witnesses who appear in workers' compensation cases. Also, subpoenas to bring those witnesses in are available by way of the Workers' Compensation Board. Witnesses are subject to both direct examination and cross-examination. The hearing before the board is always recorded, sometimes by a court reporter who will take down everything that's being said. At the conclusion of the hearing, the administrative law judge is going to deem that the case has been completely submitted, and then that 60-day time frame starts running. One important thing is that a workers' compensation case can be settled any time during the process. There is no prohibition against settling the case before, as we've said, during the hearing, or even after hearing during that 60-day period. For your reference, there is a terrific workers' compensation claim flow chart on pages 190 and 191 in your book. I commend that to you and ask that you take a look at it. So in summary, when employers and employees have benefit disputes, they're entitled to file for a hearing before an administrative law judge to make a final determination about contested issues. The evidentiary rules used to conduct hearings are more relaxed than those used in regular civil and criminal trials. And attorneys who represent parties in these hearings are compensated in different ways depending on which side they are representing. Employee attorneys usually are paid a contingency fee, while employer attorneys are usually paid an hourly wage. The administrative law judge makes decisions about contested issues. Prior to the hearing, the parties are permitted to engage in discovery, learn more about each other, and have several opportunities to settle cases. The actual hearing is conducted much like a trial, with witnesses testifying, exhibits being offered in order to prove the allegations of the case. Well, that's all we have for today. As always, if you have any questions or concerns, don't hesitate to contact me, and I hope you have a great rest of your week. Take care.